Good day to you and welcome to another Paddocks Club video tutorial. Today we're going to talk about minutes of sectional title meetings, and this video is designed for managing agents, for owners and for trustees. It reviews the basics of the minutes of meetings. On the discussion forum on the 9th of September, Renette Fenter of Pretoria asked her question: signature of trustee meeting minutes, do they actually need to be signed? The question was, should these be signed when they're being filed for future reference, these being the minutes that are filed in the minute book kept in the agent's office? The answer is that while prescribed management rules do not specifically require signature to confirm the adoption of minutes, this is usual practice, and it, in my view, is both sensible and necessary. The minutes get their status from the fact that their content is adopted by a resolution of a subsequent meeting, confirming that those minutes are a correct record of the earlier proceedings, and the signature of the chairperson of that meeting is the physical evidence that that particular set of minutes was the one tabled at that subsequent meeting and approved. Let's have a look at Prescribed Management Rule 34, the one in the Prescribed Management Rules that deals primarily with minutes. There is no mention of minutes in the Sectional Titles Act itself. In terms of 34.1, the trustees are obliged to keep minutes of their proceedings and cause minutes to be kept of all meetings of the body corporate in a minute book of the body corporate kept for that purpose. And they must include in the minute book a record of every unanimous and special resolution as well as any other resolution. When we go on to 34.2 and 3, the trustees are obliged to keep all minute books in perpetuity. And on the application of any owner or registered mortgagee, that's a bondholder of a unit, the trustees must make all minutes of their proceedings and the minutes of the body corporate available for inspection by that owner or bondholder. Let's take that in plain English. Trustees must take and must keep minutes of their meetings. Trustees must take and must keep minutes of body corporate meetings and keep them in a special minute book. In the minute book, the trustees must include a record of every unanimous, special or other resolution that the body corporate, that is the owners in general meeting, take. Trustees must keep all minute books as long as the scheme remains registered. Let's have a look at the retention period. That's dealt specifically in 35.3. The trustees must keep all books of account, that's the general records, for a period of 6 years. But minute books must be kept forever, as long as the scheme remains registered. And the managing agent, in terms of 49.2, is entitled to copies of those minutes. The trustees shall from time to time furnish to the managing agent copies of the minutes of all meetings of the trustees and of the body corporate. So trustees must furnish any new managing agent with copies of the minutes of their meetings. Let's just have a final word, or a few final words. Full and accurate notes should be taken, and the exact wording of any resolution should be recorded. It's important. Details of those present, of all topics discussed, and of the decisions, not necessarily the actual arguments and debate, but the decisions taken, as well as the number and value, if applicable, of all votes cast for and against any motion. These should be in the minutes. The trustees must make all the minutes of their own meetings and those of the body corporate available for inspection on the written application of any owner or any bondholder of a unit. I hope that this has been of assistance, and I look forward to discussing it with you in the discussion forum.